Yes, Your Honor.
All right, this is the judgment balance. It defeats this case from the outset to drop anger that it's not for nothing, that the agent on criminal principle is being cited time and again, that the prosecution may obtain a criminal conviction only when the evidence proves the defendant is guilty beyond reasonable doubt. I've said this is basic law in our country. And in respect to what is reasonable doubt, I read the judgment of Lord Denning in Miller versus Ministry of Pensions, 1947, second volume, Oregon and Road Reports, page 372, where Lord Denning said that that degree is well settled. It need not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean proof beyond the shadow of doubt. The law could fail to protect the community if it is admitted, if it admitted fanciful possibilities to deflect the course of justice. If the evidence is so strong against a man as to leave only a remote possibility in his favor, which can be dismissed with the sentence of course it is possible, but not in the least probable, the case is proved beyond reasonable doubt, but nothing short of that will suffice. The accused person in count number 1 is facing the offense of demanding money by menaces, contrary to Section 302 of the Penal Code. Particulars of the offense are on diverse dates between 1st day November 2021 and 3rd day of November 2021, being an employee of Safaricom Public Limited Company, and while working remotely from home, jointly with others not before the court with menaces, demanded a ransom of USD 800,000 shillings from Safaricom Public Limited Company. In the second count, he is facing the charge of unlawful disclosure of personal data contrary to Section 72(1)(b) of the Data Protection Act, number 24 of 2019. Particulars are that on diverse dates between the 1st day November 2021 and the 3rd day November 2021, being an employee of Safaricom Public Limited Company and are working remotely from home, unlawfully disclosed personal data on a manner incompatible with the purpose for which the data was collected through a third party. On the third count, the accused is charged with the offense of conspiracy to commit a felony, contrary to Section 393 of the Penal Code, and the particulars of the offense are that on diverse dates between the 1st day November 2021 and the 3rd day November 2021, while working remotely in India, being an employee of Safaricom Public Limited Company with dishonest intent and in breach of your terms of employment, processed confidential Safaricom customers' data and uploaded to a web server cloud held by Amazon Web Services. You heard all that the witnesses said. I'll go to my own analysis and the determination. Of course, you'll get the whole judgment, you read on your own.
I'm saying he's referring to previous charges, not
Now,
amended charges.
having familiarized myself with the facts, the law, and the authorities cited by the rival counsel, and to contextualize the exposition of this analysis, the design of the issues for determination are hereinafter set out in 5 various subheadings dealing with each other at a time. In event I do not make specific reference to any of the cited cases by both counsel, it is not that it is wanting in substance. The entry point of this analysis is to bring out some undisputed facts in this matter. The accused was indeed an employee of Safaricom PLC, having been employed as a data scientist in the big data department on a contract scheduled to expire in the year 2022. He is a provisioned data scientist, AI, big data, software engineering, and cloud computing. Number two, the undisputed fact is that the emails from rogerdata@protonmail.com were received by the complainant company upon breach of their data, and threats issued to publish them unless the sender is paid a sum of 800,000 USD and time period set to execute the threats. This breach was committed between 31st of October 2021 and 3rd November 2021. This then triggered the investigations in this matter to establish who had hacked the Safaricom BRC server. Now, upon arrest of the accused person traveling back to the country from India at JKIA, the arresting officers took possession of the accused's laptop and a mobile phone, which was subjected to forensic examination, and the outcome was that there was nothing recovered from the ring which linked the accused to the offenses he's facing. With this backdrop, it was clear from the prosecution case that there was no direct evidence as to who the suspect was, and so the investigators heavily relied on circumstantial evidence in a bid to prove their case as obligated by criminal law principles. Now, what is circumstantial evidence? It means evidence that leads to prove a fact indirectly by proving other events or circumstances which afford a basis for reasonable inference of the occurrence of the fact at issue. The circumstances should be of conclusive nature, and they should be such as to exclude every hypothesis but the one proposed to be proved. Circumstantial evidence is that evidence which enables a court to deduce a particular fact from circumstances or facts that have been proved. Such evidence can form a strong basis for proving the guilt of an accused person, just as direct evidence. Way back in 1928, Lord Edward CJ, in the case of Ard versus Taylor, Weaver and Donovan, criminal application number R21, had this to say on circumstantial evidence. Quote, it has been said that the evidence against the applicant is circumstantial. So it is, but circumstantial evidence is very often the best evidence. It is evidence of surrounding circumstances which by intensified examination is capable of proving a proposition with the accuracy of mathematics. It is not the derogation from evidence to say that it is circumstantial. And so, in the case of Tapa versus R, AC480, an English case, the court said the following, I quote, it is necessary before drawing the inference of the accused guilty from circumstantial evidence to be sure that there are no other coexisting circumstances which could weaken or destroy the inference. Taylor, on evidence, 11th edition at page 74, this is what he said. The circumstances must be such as to produce moral certainty to the exclusion of every reasonable doubt, end quote. The doctrine of circumstantial evidence was also discussed in the Supreme Court of India in the case of Anjani Kumar Sharma versus the state of Assam, criminal appeal number 560 of 2014, where the judges said the following. The circumstances of last sin cannot by itself form the basis of holding the accused guilty of an offense. There must be something more establishing connectivity between the accused and the crime. It is clear from the above that in a case where the other links have been satisfactorily made out and the circumstances point to the guilt of an accused person, the circumstance of last sin together and absence of explanation could provide an additional link which completes the chain. In the absence of proof of other circumstances, the only circumstances of last sin together and the absence of satisfactory explanation cannot be made the basis of conviction, end quote. Now, in Kenya, we have this case of Samson Lotuke Loitasia versus the Republic, 2017. And the case of Elias Onyango versus the Republic, Criminal Appeal number 32 of 2019. The following was set out as things for the court to consider in a case of circumstantial evidence. Number one, the circumstance from which an inference of guilt is sought to be drawn must be cogently and firmly established. Two, those circumstances should be of definite tendency and erring points towards the guilt of an accused person. Number three, the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused person and none else. And at this level of circumstance evidence and this level of circumstantial evidence should unerringly point to the guilt of the accused person. But in the case of Singh versus Republic, Criminal Appeal number 10 of 1997, the court said, for our part, we think that if there be other coexisting circumstances which could weaken or destroy the inference of guilty, then the case has not been proven beyond any reasonable doubt, and an accused is entitled to an acquittal. Mwangi and another versus Republic 2004, the Court of Appeal held that in a case depending on circumstantial evidence, each link of the chain must be closely and separately examined to determine its strength before the whole chain can be put together and a conclusion drawn that the chain of events as proved is incapable of explanation on any other reasonable hypothesis except the hypothesis that the accused is guilty of the offense. One more case, James Moretti Njoroge versus Republic 2016. The court that is said there are very clear parameters that the prosecution should meet when relying on circumstantial evidence. Those parameters are that the evidence tendered by the prosecution does not irresistibly point to the suspect to the exclusion of others within the meaning of R versus Kipkering, Arabkowski, and another 16 ESCA 135. Now, this court has been able to sample these great works of our superior courts to get a handle how the facts in this case roll out and how they relate to the principle of circumstantial evidence. I start with the first one on expert evidence. It is important to bear in mind the criteria courts should use to weigh the probative value of expert evidence. This is because while expert evidence is important evidence, it is nevertheless merely part of the evidence which the court has to take into account. You'll get this one in the case of Huntley versus Simmons, 2010, WCA case number 54. Now, 4 consequences flow from this as reiterated in the case of Stephen Wangondo versus the Act Limited High Court Civil Appeal number 2, 2014. Number 1, the first consequence is expert evidence does not trump all other evidence. It is axiomatic that judges are entitled to disagree with an expert witness. Expert evidence should be tested against known facts as it is a primary factual evidence which is of the greatest importance. It is therefore necessary to ensure that expert evidence is not elevated into a fixed framework or formula against which actions are then to be rigidly charged with mathematical precision. Second consequence is that a judge must not consider expert evidence in a vacuum. It should not therefore be artificially separated from the rest of the evidence. To do so is a structural failing. A court's findings will often derive from the interaction of its views on the factual and the expert evidence taken together. The more persuasive the elements of the factual evidence will assist the court in the forming its views on the expert testimony and vice versa. For example, expert evidence can provide a framework for the consideration of other evidence. Consequence number 3, where there is conflicting expert opinion, a judge should test it against the background of all other evidence in the case which they accept in order to decide which expert evidence is to be preferred. Number 4, a judge should consider all the evidence in the case, including that of the experts, before making any finding or fact, even provisional ones. This is the case of Jacto Transport Limited versus Direct Hall 2005 EWCA. This is the Canadian decision. A further criterion for assessing an expert's evidence focuses on the quality of the expert's reasoning. A court should examine the expert's testimony in terms of its rationality and internal consistency in relation to all the evidence presented. In Rothstone Limited versus Minorities Finance Limited, and another together with Same and Bird and others 1997 in PCC, Judge Jacob observed that what really mattered in most cases was the reason given for an expert's opinion, noting that a well-constructed expert report containing opinion evidence sets out both the opinion and the reasons for it. The judge briefly commented, if reasons stand up, the opinion does. If not. A court should not therefore allow an expert merely to present their conclusion without also presenting the analytical process by which they reached that conclusion. Now, bearing this in mind, the court was treated with 2 versions of expert opinions. While one set was given by the prosecution case, the other 2 sets were given by the defense. The 2 sets, that is the prosecution and the defense, are at variance. It is upon the court to weigh and come to a conclusion which version of the opinion reports will assist it. In Cross on Evidence, 5th edition at page 446, the following passage from the judgment of President Kuba in the case of Davy versus Edinburgh Magistrates 1933, Supreme Court. He had this to say on experts. Their duty is to furnish the court or a jury with the necessary scientific criteria for testing the accuracy of their conclusions, so as to enable the judge or the jury to form their own independent judgment by the application of this criteria to the facts put in evidence. So an expert witness who hopes to carry weight in a court of law must, before giving his opinion, number 1, established by evidence that he is specially skilled in his science or art. 2, instruct the court in the criteria of his science or art, so that the court may itself test the accuracy of his opinion and also from its own independent opinion by applying these criteria to the facts proved. And number 3, that he must give evidence of the facts to which may be facts ascertained by him or facts reported to him by another witness. So that under the category of expert evidence, and the general rule is that questions regarding admissibility, qualifications, relevance, and the competence of expert testimony are left to the discretion of the court. Expert testimony must be subject to vigorous cross-examination and ought to be weighed along with other evidence. The report, the state right on, was compiled and relied on the images and instructions which show the username Silaka. And this conclusion was that it was the accused password used to breach the Safaricom data. However, the expert reports by DW number 1 and the Psychiran DW number 6 were of contrary opinion, and scientifically proved that the images used were in a format with undo icon, meaning that it was subject to manipulation. Anybody can delete and insert whatever information that suits him. There is no rebuttal made to this aspect of the second set of the report, that the instructions were in a format that was editable, hence subject to manipulation by an interested party, And as such, I believe the defense expert report are at this moment, before I go far, more reliable. I emphasize that the expert must be able to provide impartial, unbiased, objective evidence on the matters within their field of expertise. I found a useful guidance from a passage from a judgment by Sir George Jessel MR in the case of Bringer versus Aston, 1873, 17, page 358, where the judge said, quote, almost 100 years later, Lord Wolf joined the list of critics of expert opinions in his Access to Civil Justice report. Quote, expert witnesses used to be genuinely independent experts, men of outstanding eminence in their field. Today, they are in practice hired guns. There is a new breed of litigation hangers on whose main expertise is to craft reports which will conceal anything that might be to the disadvantage of their client. Lord Wolf, Access to Justice interim report on civil justice system in England and Wales. The second aspect is to comment on the emails that brought about this case. There was the prosecution case that the emails in issue were traced to California, US, and Geneva. The investigation of SAPID number 8 formed an opinion to extend these investigations and all inquiries to US and Geneva to establish the owner of the email account. He did a letter to those countries, but was advised to journal the inquiries through the authorities and properly engage the Interpol. He did a letter to the ODPP to facilitate the legal assistance, but was advised to use the local forensic reports available. The investigation officer under cross-examination said that he was unable to visit the US and Geneva probably on account of logistics. Was critical to confirm with certainty the owner and the sender of those emails and rule out any suspicions. The custodian of the source of the emails were ready to assist and supply the information required, only if proper channels were pursued. Another area I want to comment is about failure to call some witnesses. Section 143 of the Evidence Act is very clear that it provides that no particular number of witnesses shall, in the absence of any provision of law to the contrary, be required for the proof of any fact. And so, in Donna Demachiwa, Chiliwa, and two other versus the Republic, the court stated the law as it is present stands is that the prosecution is obliged to call the witnesses, even though some of them may be giving advice in order to establish the truth in a case. Also, in the case of Republic, first getting Arakoski and another 1949 rather, 16 years CA 1.1. In order to justify the inference of guilty, then inculpatory facts must be incompatible with the innocence of the accused and incapable of explanation upon any other reasonable hypothesis than that of his guilt. The burden proving facts which justify the drawing of the inference from the facts to the exclusion of any other reasonable hypothesis, innocence is on the prosecution and always remains with the prosecution. It is a burden which never shifts to the accused party. Similar provisions were said in Bugenya versus Uganda 1972 East Africa, also in the case of Julius Kalewa Mtunga versus the Republic Criminal Appeal number 32 of 2005, where the law said that as a general principle of law, whether a witness should be called by the prosecution is a matter within their discretion, and an appeal could not be, and the appeal court will not interfere with the exercise of that discretion unless, for example, it is shown that the prosecution was influenced by some oblique motive. Two issues here on failure to call the witnesses. Number one, the court was concerned with George Matuthu, who did communicate that the server would be open August 2021 to 6 September 2021 and then close. This witness did not come to court and confirm indeed the server was open for after 6 September 2021 for the staff to continue using the internet. This witness was critical because it was in evidence that without Safaricom internet, the server was inaccessible. The process was that when one wants to access the server, MFA calls is made, and when it is accepted, then one is able to access using a laptop. It is alleged that the accused accessed the server, and so it was necessary to be sure the internet was on after the 6th September 2021, and that the accused received MFA call for the purposes of accessing the server. Additionally, there was a need to call a witness from Geneva and California, US, being the custodians of the emails at the center of this matter. And then the only inference the court can draw from failure to call these witnesses is that had they been called, they could have tended to give unfavorable evidence to the state and favorable to the defense. The other one aspect I want to consider is incomplete investigations. The initial investigations, when things were still hot, revealed that it was necessary to extend the investigations to US and Switzerland, being the source of the emails that were at the center of the matter. PW number 8 did his best and did a letter to Geneva, but was advised to use the authorities as instead, and so he contacted the ODDP, who undertook to assist the investigations. There was no much forthcoming, and so he was advised to use the expert report as the only material in the matter. It must be recalled that Geneva was ready to assist if only proper channels were used, and I believe US and Geneva, being the centerpiece of the data breach, it was critical that they gave an input as to the owner of the emails in issue. Put differently, that could have been direct evidence, but it was not pursued. In the same breath, no investigations were ever extended to India to establish whether or not the accused was in Hyderabad or another city 600 kilometers away the time the data breach was committed. It was in a report that the same IP address was used in these two locations, that's Hyderabad and the other city, at the same time, which is impractical. So placing the accused at the scene of crime was critical. This was also not done. Finally, there was no evidence that the accused ever visited US or Geneva during the period of the commission of the breach. Finally, I want to talk about the charges that the accused is facing. The Court of Appeals, Survey versus Republic 2003, it said, suspicion, however strong, cannot provide the basis of inferring guilt, which must be proved by evidence beyond reasonable doubt. Equally, Mary Wanjiko Ishiro versus the Public Criminal Appeal number 17, 1998, the same court said suspicion of a strong cannot provide a basis for interfering, which must be proved by evidence. Before a court of law can convict an accused person of an offense, it ought to be satisfied that the evidence against him is overwhelming and points to his guilt. This is because a conviction has the effect of taking away the accused's freedom and, at times, life. Similar view was expressed by the Tanzanian Court of Appeal, R versus Ali, in the case criminal case number 73, 2006, where the court said, I quote, suspicion, however grave, is not the basis for a conviction or criminal trial. The appellant ought to have been given the benefit of doubt. To my understanding, it could appear that the accused was charged on suspicion, having been a member of the big data team, which developed a similar data that was breached by the hackers. However, those other members of this team were, their laptops were never verified and brought as in evidence or gave evidence. In disposition, or in disposal rather, I return a verdict of acquittal under section 215 of the CPC as the prosecution has failed to prove its case beyond reserve in all the counts, and I set the accused free unless the agree and the back.
Most obliged, Your Lordship. We pray that the cash pay be refunded to the depositor.
Answer, you're muted.
We pray that the cash pay be refunded to the depositor.
And 2 phones and passports.
and the two phones and passports be returned to the accused, Your Lordship. Yes, and we pray for a copy of the ruling, the judgment.
All right, the passports to be released to the depositor. As well as the cash bail, and also a copy of the judgment to be supplied to the defense upon payment of the requisite fee. There is 14 days right of appeal.
Most obliged, Your Lordship.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Most obliged.
Most obliged, ma'am.